I acknowledge my ability to live, learn, and work in the original homelands of the Dakota and Anishinaabe peoples. I honor and acknowledge the Indigenous peoples forcibly removed from this territory whose connection remains today. I pay my respect to the elders past, present, and emerging. Thank you for joining me today. My name is Cindy Elizabeth, and I use she, they pronouns interchangeably. Today, we will discuss sex and gender discrimination as outlined in Title IX of the Education Amendments of 1972 and how this impacts our work as higher education professionals. While this presentation is an overview of discrimination, the specific focus is on the Biden administration's 2022 proposed changes, as these address some of the concerns of those who identify within and work with those in the LGBTQ community. Title IX states, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any education program or activity receiving federal financial assistance. Title IX recognizes three general types of prohibited discrimination. 1, disparative intentional treatment. 2, disparative or adverse impact. And 3, retaliation. These regulations cover admissions, financial aid, student services and counseling, athletics, physical and health education, and sex and gender-based harassment for both sexes. In addition, Title IX prohibits discrimination and harassment in any educational program activity against a person in the United States, including discrimination based on pregnancy, childbirth, or related conditions. Let's dive deeper into the different forms of discriminatory conduct. Disparative treatment refers to unwelcome or differing actions toward the person or group based on an actual or perceived protected identity. A protected identity is any of the following: race, color, creed, religion, national origin, sex, sexual orientation, gender identity or expression, familial status, disability, age, marital status, status concerning public assistance, membership or activity in a local commission, genetic information, or any other characteristic protected by applicable law. In the case of Title IX, the protected identity is sex. Non-discrimination statements, bias incident reporting, offices for institutional equity and access, and Title IX offices and officers are some of the ways institutions address discrimination based on sex. In contrast with the previous form of discrimination, adverse impact focuses on the consequences of actions or policies rather than the original intent. In other words, policies or practices that do not appear discriminatory on their face, instead they discriminate in their application or impact. The Department of Justice outlines this as evaluating facially neutral policies or practices that result in the burdens of a policy or practice being borne more heavily by members of one sex than another. Often, this language and behavior contribute to unsafe or unwelcoming environments. A modern example of this is professional grooming standards without consideration for intersectionality. Though grooming standards are uniform, enforcement adversely affects Black women with protective hairstyles and Sikh men practicing their faith. Lastly, let us discuss retaliation. Retaliatory acts, including the attempts against any individuals who have reported gender or sex discrimination, are prohibited on most college campuses. This regulation protects those asserting their Title IX rights in good faith from being intimidated, threatened, or discriminated against. In addition to the affected party, those who assist, testify, or participate in completing the investigation or grievance process are covered. Sometimes the choice not to participate is also protected. The Department of Education is an American federal agency responsible for executing and implementing laws that serve students in American schools to promote academic achievement and ensure equal educational opportunities. In 1980, the Office of Civil Rights within the Department of Education was given oversight to accomplish the latter. The OCR enforces, investigates, and regulates sex and gender-based discrimination and sexual misconduct, in addition to disability discrimination, age discrimination, and race and national origin discrimination. Students, faculty, administrative staff, on-campus vendors, and all other full or part-time employees are protected under Title IX. This act applies to public and private schools from kindergarten through graduate schools and covers recruitment, course offering and access, employment assistance, housing, facilities, services, athletics, and scholarships. In August of 1971, former United States Senator of Indiana, Birch Bayh introduced Title IX as an amendment to the Higher Education Act to the Senate, and it became law in 1972 of February. However, Title IX began its journey through all three branches of government when Representative Patsy T. Mink of Hawaii, the first woman of color and Asian American elected to the House of Representatives, introduced it into Congress. In more recent years, she has been cited as the primary author and sponsor for the legislation. Though unsuccessful, Representative Edith Green of Oregon attempted to add a ban on sex discrimination to the Higher Education Amendments of 1971. Former President Richard Nixon signed this amendment into law, and educational institutions had until July 1978 to comply. Senator Bayh was also the principal architect of the Equal Rights Amendment, a proposed constitutional amendment guaranteeing equal rights to women ratified by 35 states. Based on the U.S. Bureau of Labor Statistics Report 1097 from March 2022, the educational attainment in 2020 was 47.2% of women ages 25 to 64 who held a bachelor's degree and higher, compared with 11.2% in 1970, a difference of 36%. Additionally, in 2020, 4.8% of women in the labor force had less than a high school diploma, down from 33.5% in 1970, a difference of negative 28.7%. Pre-Title IX, women were routinely denied access and/or equal compensation to undergraduate, medical, law, and other graduate schools. Multiple class actions against colleges and universities rose to address pay gaps and industry-wide patterns of sex bias against women working in or accessing education. Title IX grew out of the civil rights movements and feminist movements in the late 1950s, 1960s, and early 1970s. To note, gaps in the timeline are not due to inaction. Instead, the timeline presents events relevant to gender and sex-based discrimination specifically, and it excludes updates that are distinct to intercollegiate athletics and sexual misconduct. As you review the timeline on screen, let's check out some of the rights and protections under Title IX through the lens of the contributing cases. On February 2nd, 1992, the Supreme Court ruled unanimously in Franklin versus Gwinnett County Public School that plaintiffs filing Title IX lawsuits are entitled to receive punitive damages when intentional action to avoid Title IX compliance is established. Likewise, in Jackson v. Birmingham Board of Education, the Supreme Court upheld that individuals, including coaches and teachers, have a right of action under Title IX if they are retaliated against for protesting sex discrimination. In 1979, Cannon versus the University of Chicago, it was established that individuals have the right to sue under Title IX, despite the absence of any express authorization for it. In Bostock versus County in 2022, it was clarified that Title IX protects discrimination based on sexual orientation and gender identity. And both in JL versus Mohawk Central School District in 2010 and Putnam versus Board of Education of Independent Schools in 20, cases affirm that Title IX prohibits discrimination when a student's behavior or appearance does not conform to stereotypes about how individuals of the student's gender are supposed to react. The ORC issued a series of Dear Colleagues letters on April 24th of 2013, June 25th of 2013, May 4th of 2014, and April of 2015 concerning higher education that reminded schools and institutions that retaliation is a violation of federal law, created literature to improve the graduation rates of young parents at secondary schools and post-secondary schools, and created regulations and guidance that apply to other public schools. The documents are listed in the transcription of this presentation, but have been formally rescinded, though they remain available online for historical purposes. As with new administrations come new policies. During the first 3 months of his presidency, President Joseph Biden released 2 executive orders clarifying and guaranteeing full protections under Title IX for those who experience discrimination on the basis of sex, including sexual orientation and gender identity. The first introduced the nation to the Biden administration stance on preventing and combating this form of discrimination. The latter is an introduction to the U.S. Department of Education's 2020 proposed amendments to current Title IX regulations. The department proposed these regulations based on 4 significant goals as outlined in the release's announcement. 1, require that all students receive appropriate support in accessing all aspects of education. 2, strengthen protections for LGBTQ+ students and discrimination based on sexual orientation or gender identity. 3, require that school procedures for complainants of sexual discrimination, including sexual violence and other sex-based harassment, are fair to all involved. And 4, reaffirm the department's core commitment to fundamental fairness for all parties, respect for the freedom of speech and academic freedom, respect for complainants' autonomy, and clear legal obligations that enable robust enforcement of Title IX. Before reading the proposed changes, one of my biggest concerns was surrounding non-binary, intersex, and gender nonconforming students. Gender encompassed my undergraduate career from the official branding and uses of she, her pronouns and terms such as sisterhood and womanhood. But what about students whose sex and/or gender comes with an asterisk? What about folks who experience intersectional forms of discrimination not solely tied to gender or sex? President Biden addresses these concerns directly in Executive Order 14021 with an understanding of the need to account for intersecting forms of prohibited discrimination and the significant rates at which LGBTQ+ students experience identity-based discrimination and harassment. These experiences, he continues, can affect the availability of resources and support for students. As we learned in Dr. F's course, marginalized communities are disproportionately impacted by sex discrimination and sexual violence. Kelsey Scarlett and Lexi Warwick, and 2021 graduates of Boston University's School of Law, cited in their article, Transforming the Focus, an intersectional lens in school response to sex discrimination. As a result, students are either forced to choose which of their identities to pursue a complaint under, or even worse, the choice is made for them. Women of color and others holding multiple marginalized identities are uniquely affected by Title IX. President Biden's acknowledgement impacts my work, especially at a Catholic college for women with a gender diverse population. As higher educational professionals, it is vital that we expressly recognize that intersectional impact and establish continuancy within our standards and policies. More modern research has been emerging around these central questions. How are we approaching Title IX with an intersectional framework? And how should an intersectional framework inform how higher education professionals approach Title IX? The Department of Education opened the proposed Title IX regulations for public comment 60 days after its initial release to facilitate ongoing dialogue between the department and the public to be active and informed on the policies that may affect them. As a result, the Federal Register received over 200,000 comments between July 11th and September 12th of 2022. All public school districts, public colleges, universities, and nearly all private colleges that receive federal financial assistance are covered by Title IX. However, few institutions receive exemptions from Title IX. As of March 2021, Title IX does not apply to an educational institution that is controlled by a religious organization to the extent that the application of Title IX would be inconsistent with the religious tenets of the organization. Most exemptions are in regards to membership and admissions, but all educational institutions are accountable for discriminatory discipline, discrimination based on sexual orientation or gender identity, and unequal access to educational resources. All educational institutions and districts that receive federal funding must identify at least one employee to ensure compliance, typically to refer as the Title IX coordinator. There may be more than one title coordinator to better address student to student, student to faculty, and employee to employee discrimination found to be in violation of Title IX. Financial costs associated with Title IX include training committees and investigators, counselors, Title IX coordinator salaries, legal services, personnel associated expenses, and survivor resources such as counseling, medical treatment, accommodations, and mental health services. The Office of Civil Rights believes schools should provide accommodations at no cost to survivors, such as counseling, and reimburse all financial costs of violence, such as property damage or early termination penalties when it is related to housing affiliated with an educational institution. These costs, however, are expected to be covered by the institution, not by the Department of Education or the offices within that division. The Department of Education states that schools must publicize the Title IX coordinator's information on handbooks and catalogs, in addition to being promptly posted on the institution's website. For colleges and universities to be found non-compliant, a significant consequence can be the withdrawal of federal funding, including money designated for student loans. Title IX's protections reaffirm the right for all to be educated and work in an environment free of discrimination, intimidation, and bias. To enhance protections from sex or gender-based discrimination, Title IX has impacted the quality of one student's experience by creating avenues and support for affected parties to seek justice and hold institutions accountable, protections and preventions towards violations and retaliation, prohibiting discriminatory admission practices, codify sex discrimination based on biological sex, actual or perceived sexual orientation and expression, and gender stereotypes, ensuring equal treatment for women's and men's athletics, and allowing routes for pregnant and parenting women to continue their education. The regulations as they currently stand do reflect the purpose and the impact. Title IX protects the right to educational environments, experience, and programs that are free of harassment, violence, and harm. When these were first created, we did not have the gender expansive vocabulary we have now, nor did we understand the difference between gender and sex. My significant concerns about actual perceived gender expression protections are addressed in the proposed changes. Should these regulations become law, I believe students marginalized based on gender, stereotypical masculine and feminine roles and expression, or gender identity and expression will have more support avenues and resources for alleviating or remedying discrimination they face. Despite the leaves of education reform and protections granted over its 50-year legacy, Title IX purpose has not changed. There is still work to be done. Future regulations will need to be addressed in future discrimination and harassment regulations that address misgendering or dead naming those who have transitioned or affirmed their identity. Though not the focus of this presentation, Title IX will also need to address non-binary, intersex, additionally, and trans expansive students in athletic and single-gendered colleges. As an alumna of the Women's College that directly and currently benefits from Title IX and grants from the Office on Violence Against Women within the ORC, I was stunned that I did not actually understand Title IX at all. I had a loose understanding of what it meant and how it related to sexual assault, but outside of Olivia Benson and what Law and Order could provide, I didn't know that much. Moving forward, this focus on discrimination will allow my work to be more precise, especially concerning bias-related incidents on perceived or actual gender, non-binary and femme inclusion, and policy mandates, and advocacy for the Equal Rights Amendment. This assignment has opened my eyes to the way that the law can impact higher education practice, whether the school is public or private. It is a comfort to know that these are universally accepted as best practices should they come up in my work. I enjoyed reviewing the timeline of Title IX because it highlighted how one group fight for access and inclusion can create avenues for others. The Civil Rights Act is to thank for other inclusion policies, such as the previously mentioned ERA, Individuals with Disabilities Education Act, Executive Order 13988 on the enforcement of the Fair Housing Act, and Every Student Succeeds. In closing, I leave you with the question I posed earlier in this presentation. How can we be aware of the reality that folks experience harassment and violence based on unique intersections of multiple identities, and how should this inform our work? If you are looking for a place to start, I encourage you to watch the video provided in the QR code to learn more. Thank you.